Gladden was I believe that Mr. Gladden was arrested and brought before me on August 23rd, 2021. As to the charge of sexual assault of a child, I believe I set bond at $50,000 with some conditions of bond, as well as the charge of online solicitation of a minor at $10,000. A risk assessment was performed. I believe that on that risk assessment, Mr. Gladden came back at a 16, which is a high, well, it's moderate to high. High is considered 17 and above. But I think it was partly based on 3 arrests in the past 10 years and the nature of the charges currently. I don't think there was a question as to his, he had not resided at the same residence for the last 3 years. That may be a reflection, however, in reading the motion by the defendant's attorney, I believe he had been in a residential treatment facility, so that may have accounted for part of that. And his age, which is, if he's under 25, that cost a point or so on the risk assessment. So just full disclosure, that's what I was looking at as far as a risk assessment. Bond set at 50,000, 10,000 was current conditions of bond. So with that in mind, I have received a motion to modify or reduce bond filed by Mr. Nathan Miller. Set this for a hearing. I believe there was no agreement as to that. So Ms. Joe-Lettis is appearing on behalf of the state. And Mr. Miller, this is your motion. So if you'd like to tell us where you'd like to go with this.
Yes, Judge. If I first may confirm with Ms. Cummings that my witness is in our waiting room. Her name is Tamber Presti.
That is correct. She is in the waiting room.
Okay, very good. I'll be calling her, Judge, but if I may just briefly kind of give you a roadmap of the testimony I intend to elicit. Taking guidance from the Code of Criminal Procedure, Article 1715, I'm going to provide some testimony for the court regarding factors 1 through 5, sufficiently high to give reasonable assurance that he'll appear in court for hearings after indictment. 2, not to be used as an instrument of oppression. 3, the nature and circumstances under which this offense was committed. I believe the witness has a little bit more detail. Of course, the court also has the probable cause affidavit. The 4th would be the ability to make bail. I'll spend some time informing the court about this family's financial situation. And then 5, the future safety of our alleged victim in this case. And then, of course, the safety of the community. And then I'll briefly go through 6 additional factors, and I'll hit them right in a row, Judge, taking some guidance from Ex parte Rubac, RUBAC. That is citation 611, Southwest 2nd, 848. That's a Texas Court of Criminal Appeals case out of 81 that's still emergency sirens over here. Thank you. So I'll ask our witness about his work record, his family ties, length of residency, prior criminal record, conformity with conditions of any previous bonds, and then the existence of outstanding bonds. Judge, our situation with bonds is that Jordan had a prior, I think, January 2020 arrest for possession of THC, a vape cartridge, state jail felony in Tarrant County. That case was indicted and he failed to appear at the initial court date. His mother, Tamber, has more information there. But the judge forfeited that bond. There is no bond, so he's actually being held on our 2 cases here in Denton County, but also that 3rd case out of Tarrant County, which is already indicted. So that's it in a nutshell. If I may call my only witness, which will be Mr. Gladden's mom, Tamber Presti.
All right, then Ms. Cummings, if you let Ms. Presti in, please. You are Tamber Presti, is that correct?
Yes, sir. Yes,
Ms.
Your Honor.
Presti, can you hear and see everyone on the screen?
Yes, sir, I can, Your Honor.
For your benefit, we have Ms. Shilvett, who is the prosecutor or a prosecutor with the Denton County District Attorney's Office. Of course, Mr. Miller, who is Mr. Gladden's attorney, and my name is Robin Rance. I'm a magistrate or judge for Denton County. This case is still on file, has not been indicted, so for a very brief time, I would have some ability to hear and modify bond. I also set the original bond, but that case is subject to grand jury indictment. And when that happens, a different court with full jurisdictional ability will take over that case. So just as a matter of explanation to you. We also have Jordan's here with us in the courtroom. Mr. Miller has called you as a witness. So at this time, let me have you raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you very much. You may put your hand down. Mr. Miller, you're a witness.
Ms. Presti, how are you related to Jordan Gladden?
I'm his mother,
How old is Jordan?
22.
How old was Jordan on the date of this alleged offense, March 18, 2021? Was he still 21?
He was 22 on March 2nd.
Yes. Let's see. The items we're going to talk about are things that we've discussed by phone. And I'm going to go rather quickly for the court. Judge Ramsey's
sir.
done a lot of these, okay? So
Yes, sir.
don't be offended if it's rather quick. We all know the factors the court's to consider here. The bonds that are currently set at $50,000 and $10,000 respectively arise out of basically the same situation. Are you aware that Jordan allegedly had an improper relationship with a minor, that is a young lady under the age of 17, and that was sexual in nature? Are you aware of those allegations?
Yes.
And are you also aware that connected with that are alleged some communications, you know, text messages and so forth, that were sexual in nature with the same young lady?
Yes.
Okay. And I've represented Jordan in the past, correct?
Yes.
On a misdemeanor possession of an inhalant, like a little whippet,
Yes.
which is a misdemeanor charge, and also possession of a vape cartridge. Those were out of the same arrest, the same what we call transaction in Roanoke, Texas. Is that correct?
Yes.
Is that where y'all lived at the time?
Yes.
And was he a few years younger back then?
Yes.
Has drug abuse been a problem for Jordan for a number of years?
Yes.
And I would imagine that that you're aware of the Tarrant County charge as well, which was a second possession of a THC cartridge, also a state jail felony, correct?
Yes.
And that was from January of 2020.
Yes.
All right. The bonds in Judge Ramsey's jurisdiction right now need to be sufficiently high to make sure Jordan's going to show up for court. Are you aware that if bonded out and he is released on custody, that there's a financial aspect to him coming to court? If he does not show up to court, your family would be responsible, or he would be responsible, and your family as a surety for paying that bond. Are you aware of that?
Yes.
You hired me to represent him on this sexual assault of a child and online solicitation case, and also the Tarrant County case. Did you have the money to do that at the time?
No.
Did you have to request a disbursement to withdraw from your 401k savings in order to hire me?
Yes.
And did you discuss that with your husband, Jordan's stepfather?
Yes.
And after some consideration, did y'all decide to do that, to hire me and bring me aboard early?
Yes.
Was one of the reasons you guys decided to do that so that Jordan could, if released on bond, begin immediate treatment with an LSOTP, sex offender treatment provider?
Yes.
You understand the importance of that in these cases,
Yes.
especially with a younger defendant?
Yes.
Do you understand that the question, if he is guilty, will likely be whether Jordan needs to go to prison or whether he needs to be on court-ordered supervision, what we call probation, But either way, he's going to register as a sex offender if he's guilty.
Yes.
Have we discussed all those things?
Yes, sir.
Have we also discussed that it's usually more likely that someone be offered a chance at probation if they are well on their way through treatment?
Yes.
Are you aware of whether he's getting any treatment while he's in jail?
I'm not aware if he is in jail, not at all.
Would an amount of $10,000 or even $20,000 be sufficient to financially ensure that he's going to show up for court as ordered after he's indicted?
Yes.
In other words, is $60,000 the aggregate cumulative amount of $60,000 necessary to ensure that he's going to appear as ordered?
No.
Okay. The nature and circumstances of this case are not good. Anytime there's a child victim, the court and the DA's office, they take these cases seriously. Do you understand why?
Yes, sir.
All right. Do you understand, based on your reading of the probable cause affidavit in this case and discussions with family, Jordan's siblings, that this alleged victim was a known person to Jordan, somebody that he met through social groups in town?
Yes.
So it wasn't a stranger offense?
No.
Is this somebody that Jordan had a friendship with long before it became sexual, to your knowledge?
To my knowledge, yes.
To your knowledge, did she consent in these acts, although not legally consent because she is underage?
Yes.
Are you aware of any allegation of forced sexual conduct or violent sexual conduct in these cases?
No, no, sir.
Do you and your family have the ability financially to make the bonds as currently set?
No, sir.
Does Jordan have the ability to make the bonds as currently set?
No, sir.
Does Jordan have any assets, real property to his name?
No, sir.
No house?
No.
No car?
No.
Was he working at Chili's before he voluntarily surrendered on these warrants, right? Was he
Yes.
working at Chili's? Was he making an hourly wage plus tips?
Yes.
When he learned of the warrants, did we sit down and plan a surrender to the county jail?
Yes, we did.
Was he living at a sober living house called The Real Deal at that time?
Yes.
Did he at the time pay a monthly rent for that sober living house?
Yes.
And did he continue working another week or so at Chili's so that he could pay off that month's rent before surrendering on the warrants?
Yes, he did.
All right. To date, does he have more or less than $100 to his name?
Less.
More or less than 50?
Less.
With regard to the alleged victim in this case, a young lady, I'll refer to her as Jane Doe, okay?
Mm-hmm.
Has your younger, I guess, daughter, who's 19 or so,
Mm-hmm.
and then her younger brother, your son, what, 15 or 15 years old?
14.
Have they learned through their social network of friends that this young lady may not even live in the state of Texas anymore?
Yes, correct.
Where do you believe that she lives?
Florida. I was told Florida. I don't know where, but Florida.
Has Jordan had any contact with her since the spring of 2021, to your knowledge?
No.
When talked to by her father, did Jordan cease all communication and contact with Jane Doe?
Yes.
Did y'all shortly thereafter become aware of a relapse and continued drug abuse?
Yes.
And did Jordan ask to go back to inpatient residential treatment?
Yes.
And did y'all, get him into Valley Hope, a
Mhm.
sober residential treatment program in Grapevine, Texas?
Yes.
And was he there for a month?
Yes.
And where did they recommend he go for aftercare?
Real Deal. He went right from there to Real Deal.
Did you pick him up from Valley Hope and drive him straight to a sober living house?
Yes.
How long was he there before he left to surrender on these warrants?
Going on his 3rd month, I believe.
And what was his progress? Did you learn anything from the director and his house manager?
Yes, we get phone calls every week by the program director, and they said that Jordan was a role model in the house, about to become a sponsor. It was going to more than meetings that are required, above and beyond what's asked for in sober living.
Did you provide to me a letter from the program director verifying those same things?
Yes,
And did you also provide to me the Valley Hope admission letter
yes,
and the Real Deal admission letter?
yes,
Have you since been told that his bed, so his spot at that particular sober living house, had to be given away to another young man?
yes,
Have you also reached out to other houses facilitated by Real Deal and also Oxford Place?
yes,
Does it look like, if released, and once the Tarrant County case is concluded, because he will go from here, if released, to Tarrant County, you understand that, right?
yes, sir.
And after we go to court, if he's placed on probation, right? Do you have somewhere for him to go?
Yes,
And does it look like it would be the Oxford Place in Tarrant County?
yes,
Right. Um, with respect to the future safety of the victim or the community, have I discussed with you some things that could be put in place electronically that would monitor Jordan's use of a cell phone, use of internet to access sexually explicit things?
yes,
Did Jordan, prior to going into jail, have an iPhone?
yes,
Did I explain to you that the software program, the app that the Community Supervision Correction Department uses, is not compatible with an iPhone?
correct.
And did you agree to instead get him an Android or just a burner phone for text message? And I guess not, he wouldn't be able to use a burner phone. It would need to be a phone that could
Yes,
be equipped with this monitoring. Are you aware of that?
yes, sir.
And I've also provided to you the name and contact information and price information for an LSOTP provider here in Denton County.
Yes,
And have we discussed beginning that right away as soon as he is released?
yes,
Okay. Do you have any reason to believe that Jordan has attempted to communicate with this young lady, uh, learning, I guess, upon learning about the charges or after?
no,
Has anyone in your family made any attempt to contact her or her family?
no,
In addition, with respect to Jordan's work record, has he, since the age of, 16 or 17 in high school, attempted to work at places to earn additional income for the family?
yes,
Mostly hourly jobs, right?
yes.
And what types of jobs and what places has he worked?
Mainly, he was real good at like the hospitality industry. So he's done that.
Can you name some specific places here locally?
Chili's, Cane's, um, there's a place, Foster's Sushi and Grill. And I'm trying to think of another one. KFC, he worked there once, two jobs, KFC and Cane's at the same time. So he's real well with customer service, so he's enjoyed doing that.
For how long how long has your family lived in Texas?
11 years,
And for how long have y'all lived in Denton County or the Roanoke area?
11 years.
Where did Jordan graduate high school?
Jordan graduated high school actually in Florida and
Okay,
then came with us.
that's where his father lives, correct?
Yes, yes,
Did Jordan go to most of his high school career in Denton County in Roanoke,
yes,
and then finished in Florida with his dad, but came back here, correct?
yes.
Um, since coming back, has he been on probation in Denton County
Yes,
for possession of inhalant and possession of THC, the felony case?
yes.
With respect to a prior criminal record, are you aware of any other alleged crimes
Mm-mm.
as an adult or a juvenile outside of the 2 felony possession of THC cases and then that contemporaneous possession of an inhalant from back in 2019?
No.
Did y'all attempt to update your address in 2020? Did you have to move because of COVID?
Yes.
Do you live in an apartment in Roanoke?
Yes, we do.
For how long have you lived in an apartment?
Going on almost 4 years now.
Okay, so you haven't owned a home in quite a long time.
No.
And when you changed apartments, did you attempt to update your address with the Tarrant County District Clerk's office?
Twice. Yes. Yes, sir.
For whatever reason, did Jordan miss his first court date after indictment in Tarrant County?
Yes, because then he was never notified.
Are you aware, and have we discussed, that if the judge lowers the bonds in these 2 cases, that we would post those bonds but leave Jordan in so that he could be transferred to Tarrant County to answer for that indicted case?
Yes.
Is our plan to let him come to court when he's called for jail chain and plead that case?
Yes.
Does Jordan's father have the financial means to assist in posting bonds?
No.
Did he even have the financial means to assist in hiring me?
No.
Does he own a home and a lot of assets?
No.
How many other children live in your home?
2.
Younger siblings of Jordan?
Yes. Faith is 19 and Logan's 14.
All right, ma'am. Thank you for your testimony. Ms. Chilavetis may have some questions for you. Even Jen Ramsey may have some questions for you, okay?
Okay.
Thank you. I'll pass the witness, sir.
Thank you.
Yes, Your Honor. First, the state would ask the court take judicial notice of the court's file, including the PC affidavit.
No objection.
That's so done.
I just have a few questions. If you'll let me know if you don't understand, I'd appreciate it. And just like you did with Mr. Miller, if you'll let me finish my question before you give your answers, okay?
Okay.
You said that you had the opportunity, I think I understood in your questioning, to review the PC affidavit in this case. Is that fair?
Yes.
Okay. So were you able to read in there that some of the allegations also included providing drugs to the victim in this case? Did you recall reading about that?
Yes.
Okay. And were you able to kind of read the sexually explicit messages?
Yes.
And the kind of blurb in there about the forensic interview in which she talked about this was kind of an ongoing, had happened up to 10 times. Did you read about that?
Yes.
Okay. And it's my understanding, and I'm not perfect on the timeline here, but this did occur while he was living in the sober living home. Is that correct?
No.
Okay. Well, where was he living at the time?
He was with us. He was with us, and then we were trying to find him sober living again.
Okay.
He was with us.
Okay. And at that time, I guess y'all were the primary supervision for him during this time?
Yes. I mean, we work, but yes. Mm-hmm.
Okay. And you said that you had lined up Oxford sober living. Did I understand that correctly?
Well, we were looking at sober livings. We were looking at Real Deal and looking at a few. Yeah, we pretty much Real Deal is what we were looking at the time.
Okay, I'm sorry, I was not clear on my question. Right now, the plan, if you were
Oh, I'm sorry. Yes, ma'am. Oxford House is what we're looking at. Yes.
Okay. Are they aware as to the nature of the charges that he's looking at?
We haven't gotten that far to discuss with them, anything like that.
So they don't know that he could be in the near future under indictment for sexual assault of a child?
No.
Okay. If that plan falls through, what's the next plan?
we would go to another sober living. There's plenty, and I have a lot of resources that I would go, but I've talked to two, and they're wanting to interview Jordan to live
Okay,
in the house.
Are they aware of the charges against him?
No.
Okay. You said you have a lot of resources. What kind of resources are you talking about?
Well, I know of a few. Real Deal has still said if they can find a place for Jordan, they would love to have him back there. Oxford House and also Solutions, which he's been at as well before. I've had contact with them also.
Okay, so when was the first stint that he stayed with Real Deal? So I'm better on my timeline.
Let me think. I'm trying to think when I got him out. I don't have all of the papers in front of me. May, I believe, was when he first started Real Deal.
Okay, May of 2021.
Yes, of this year.
Okay. You said that you do have younger children living in the home. Is that fair?
Yes.
Okay. And it sounds like that they've got an active social life and have their own friends. Is that fair?
Yes.
So Jordan would have access to underage children. Is that fair?
Just to his brother. They don't, I mean, no one else really comes in the house, just his brother and sister.
Because you understand that if the judge is inclined to lower the bond, that there could be added restrictions that require potentially, in the judge's discretion, no access to any children under the age of 18. Is that something that you think he can comply with?
Yes.
Is it fair to say that he has a history of some pretty deceptive behavior?
I mean, I'm going to say yes, but because of some problems with drugs, but I don't think he's deceptive, as far as himself, him being a person.
And I'm not trying to trap you, okay? I'm just, there is an acknowledgement that he has had, while living in your home, some issues with relapses, and then
Yes.
this incident occurring as well.
Yes, ma'am.
Okay. And that he was placed on deferred state jail felony probation in March of 2021. Is that fair?
Yeah, February, but is when it happened, but I guess he reported in March. But yeah, February is when it started.
And that this was going on during that initial period of his probation. Is that fair? The contact with the 14-year-old minor and meeting up for sex and providing drugs.
Yes.
Okay.
That's what I was told.
And you understand that it may be difficult under some of the potential bond conditions to get a job in the hospitality industry. Do you understand that? As far as having access and being near children.
Yes.
Okay. Is your family prepared to deal with that financially?
Yes.
Have you looked at any of the licensed sex offender treatment counselors that Mr. Miller has provided to you?
Yes, and I have things through work and benefits too I can look at to get somebody. Yes.
And it sounds like you've done a lot of work. Have you talked to your son about this and what he's looking at?
Yes.
Okay. And that treatment can be pretty intense.
Yes.
Okay. You said that am I correct that Jordan's father lives in Florida?
Mm-hmm. His biological father.
Okay. Does he still have contact with him?
By phone only. He doesn't
Okay.
get to see him. No.
So no trips to Florida planned or anything like that?
No.
Okay. I got concerned when I heard the two.
No, it just happened to be, I guess everyone wants to be in Florida. I don't know.
Okay. I don't have any further questions. I'll pass the witness.
Mr. Miller?
No, sir, I don't have any questions. Thank you, Ms. Presti. Thank you, Your Honor.
Thank you.
Mr. Miller, do you have any other witnesses, testimony, or evidence that you'd like to present to the court, or any additional exhibits?
No, Judge, we'll rest on that testimony.
Joe Vettis, do you have anything that you want to present to the court?
Judge, I don't have access to the, I know you said that it was a $60,000 bond with additional conditions. I'm not sure of what the other conditions that were put on. But obviously would want something similar that when this case is indicted to what he would be facing, such as no access to children under the age of 18, and those typical parameters that are associated with a case like this. The state does have grave concern. I mean, his next stop after Tarrant County would be home, which is where a lot of these incidences have occurred and relapses, and no fault, I'm sure, to the efforts of his family, but clearly he's been able to circumvent that system before, and that does cause grave concern because whether he had a prior friendship with her or not, it was a 14-year-old girl that we're talking about here with some pretty extreme explicit behavior and manipulation on his part as well. So as far as a number, obviously in court's discretion, just concern from the state.
Okay. Well, I certainly do embrace the concept of bond should not be punitive in nature, but it is intended to protect the community and public as a whole. So, and I do have some very serious reservations about this. This is a highly manipulative behavior, if true, and there was a direct victim in this particular case. On the plus side, for Mr. Gladden at least, he did surrender. He did make himself available. He does have a support system there. He obviously has a mother who still loves him very, very much and would like to do the best that she can for him. Mr. Gladden, this is a long, long process. I think you're probably aware of that. You have very good legal counsel, so I need for you to listen to that legal counsel. I will agree to do this. I will reduce the $50,000 bond to $25,000, and the second bond, I think, is set at $10,000. I will reduce it. I'll keep it at $10,000. So that means a total of $35,000 in bond. Mr. Miller, do you think your client can make that bond?
I don't know, Your Honor. I don't know the answer to that question, but I'll discuss it with Ms. Presti. Yeah.
Let me ask you a few other questions about in fact, I guess I'm wavering a little bit on that. The licensed sex offender treatment program, have you found a place where he could get into that?
Yes, Judge, the specific counselor we've been discussing is Jeff Fletcher. He's an approved LSOTP, very familiar with Denton County. Denton County CSCD is very familiar with him as well. It is $1,500 to get started. It begins with a risk assessment and psychosexual evaluation. Thereafter, he pays for individual counseling and group counseling, and it's many, many months long. I would say years long. Every polygraph costs money, but these are financial. His family can pay for that. She withdrew I guess a number from her retirement account, or all of it, with those things in mind. But Jordan will be expected to work at any sober living, Real Deal included. They're required to get a job and pay their way. So some of this cost for treatment would be on him. I know I didn't get to make any kind of closing argument, Judge, but if I may, just one thing. The money side is one thing, of course, but I think the court's power here to both protect the community, to honor the fact that this is a crime with an alleged victim who's 15, now 16, according to the PC affidavit, and but also get this young man involved in some treatment as soon as possible, would be those conditions. I submitted a proposed order to Ms. Chilavetes and included electronic monitoring, LSOTP counseling, and then reporting, of course, to pretrial services for those things. They also charge $60 a month for the supervision fees there. So If the court can set the bond as low as possible, but also add as many conditions as possible, I think that would satisfy everybody's concerns and help us reach some goals to actually make bond and get him started.
One of the other things I'm concerned about, and I apologize for not giving y'all both final summation. And Ms. Chilavetes may want to respond to this, but or maybe not, but I am concerned that there will be additional charges for sexual assault of a child that could come from this. Well, I don't know about sexual assault of a child, but at least additional charges due to the actual sexual acts that may have occurred or alleged to have occurred by this statement given by the alleged victim. In that particular event, they'll lose, Miss Presti will lose her money, and Mr. Gladden will end right back up in jail. Is there a plan, or Miss Chilavetes, do you have a response related to the amount of bail for this case in light of those particular potential charges?
I mean, it definitely plays a role in my concern and why there wasn't a prior agreement to this hearing. I have left a message with the detective to try to figure out the plan, since he has been in jail 30 days, as to when I can get my hands on the full file to determine what potential charges. I can say in my experience in this court in the last couple of years that I anticipate that where charges are available when it comes to sexual assault of a child, they will be filed. Now, because of her age, I don't necessarily think there's a continuous charge or something like that, but I do anticipate that there could be multiple charges.
What I have seen, in Ms. Chilavetes probably as well, is that on an indictment for sexual assault of a child, if through the investigation they identify more than one alleged offense date, those could be additional counts. It wouldn't necessarily result in a new warrant, but of course the indictment warrant could be higher, right, Emily?
True. I mean, as I can speak for myself, that I don't typically add additional. Each prosecutor is different, but I do tend to do counts. And then if there's a bond already set, then it's just up to that judge. If looking at the charge, they decide to raise it. Right. I know that Judge Breeding, if it gets put in her court, is pretty quick to respond to any kind of request for a bond reduction or something like that, and would entertain that these are existing acts prior to the charges if more are added.
All right, then Ms. Chilavetes, did you want any final summation or statement? I cut y'all off. I apologize.
No, sir.
Thank you for your time, Judge.
Mr. Gladden, I really feel for your mom. I feel for you. I feel for everybody. I feel for the victim, alleged victim. But I really feel for your mom. I will say you had good legal advice and you did turn yourself in. And all the things that are set out in Article 17, 15 Code of Criminal Procedure, they're all true. And those things that we need to embrace. So the conditions, I suppose, are more important, and I do want you to receive treatment, so I'll agree to reduce the one from 50,000 to 15,000. So that's a total of that'll make 25,000. I'm not willing to reduce the. Again, Mr. Miller, in reading the affidavit, the texting that was going on was particularly disturbing to me.
Yes, Judge.
So I'm not willing to reduce that one.
Understood.
I am afraid that Ms. Presti runs a risk of losing any money that she posts. If these other charges come down the pike, but and I will have to say, Ms. Jill, that is from a jail standpoint, additional counts wreaks havoc on which ones, how much is the bond on each one. But then I digress. It's just that kind of switch over. We're going toward counts now, and those counts become kind of problematic when we reduce one, but I'll leave that up to the district courts. So the one stage that where it was at 10,000, my general parameters, and I can tell Mr. Chilavetes didn't receive a copy of those, but the conditions that I would require are pretty comprehensive. That is, not violating laws of the state of Texas, must appear at every court date, must meet with pretrial service officer, not later than 4:00 p.m., on the first day after release from custody, and I'll keep it that way since I don't know when he's going to get out of Tarrant County, shall physically report to Denton County Community Supervision at least once a week while this case remains pending, or more frequently if told to do so. Shall provide written notice of any change of address. Shall pay $60 in monitoring fees. Shall have an attached and wear electronic monitoring device in a manner designed that does need to be attached prior to release, although if he's going to be released from Tarrant County, I'm not sure how that would apply or how we would get that done.
Judge, I know that recovery resources here in Denton County can install a GPS device same day. Perhaps we can make a note, or within 24 hours of release. That way we can get him from Tarrant straight up to Denton to get that installed. And I would ask that the court consider that he might be at a sober living house that's in a contiguous county, rather than in Denton County. We just don't have too many. So,
well, my general rule is that they can't leave Dallas County, Tarrant County, Denton County, Collin County. Those are the counties I typically restrict to.
And then, of course, not within 1,000 feet of the alleged victim or her family, correct?
That is correct. And in addition to that, though, here is a problem is I do typically require they not reside in a household where anyone under the age of 18 might reside. If he has brothers or sisters, again, that becomes problematic.
It would just be the brother who's 15, his sister's 19.
He would be living in a sober living facility anyway, would he not?
Yes, but Ms. Chilavetis brought up if there's any road bumps to getting approved, obviously he would need to probably come home until he gets in one. But I think we're all on the same page, including Mr. Gladden. He needs to go back to sober living. These houses are all male or all female. So potentially the all male house won't have an issue with the pretending charges, but we don't know until he interviews.
I probably would not have been reducing this at all, Mr. Gladden, if it were not for the fact that you turned yourself in and that you obviously have a mother that seems to want to trust and believe in you. And she's in a lot of pain. So I'm going to ask that you abide by, and I'm not going to ask, I'm going to order that you abide by every condition of these bonds if you get out. And listen to the advice of your attorney.
Yes, sir, Your Honor.
I guess I could put some language in there. Saying that he can have contact with family members only.
Judge, I have done it specifically too in our bonds, once they're indicted with specific names of individuals when it comes to a brother or something like that.
Okay, I will still require that he not accept employment or participate or go around any schools, churches, daycares, public parks, or any place where he could have contact with anyone under the age of 17. Or any place where children commonly gather. Gosh knows what that might mean, but Mr. Gladden, you have to take these things very seriously. I don't think this will be before me for very long, but if there are any violations reported, you would lose your bond, your mom would lose her money, and I will not agree to any bond that has any hope of being made. So
Yes, sir.
I did just hear from the detective supervisor that the case would be sent to us this week, just for your knowledge.
Mr. Miller, does that change the nature of the request at all?
No, Judge, thank you.
Okay. So reduce to 15,000. The other one stays where it is at 10,000 with those conditions set forth.
Thank you, sir, for your time.
All right.
Thank you, Your Honor.
Thank
All
you.
right. Thank you.
Thank you.
Bye.
Bye-bye.
Yes, we do have another hearing.
Who's from the state's going to be there on that one? Anybody?
I sent it to Michael Graves, but he's not here.
And it is a modification of a protective order.
That is correct.
Let him in.
We only have one. The other alleged victim decided not to go forward.
You must be Miss Feith, is that correct?
Yes, sir, I am.
All right. Somehow I lost the picture here. Miss Feith, my name is Robin Ramsey. I'm a judge or magistrate for Dane County. So I believe I met with Mr. Brad Michael Veith. Am I pronouncing your last name correctly?
Yes, sir, you are.
Veith. And let's see, Mr. Veith was arrested on a charge of assault, family violence, impeding breath or circulation, alleged to have occurred on September 22nd, 2021. I saw him on September 22nd. I set bail on that particular matter and also ordered a protective order, or magistrate's order for mercy protection, which is required by state law. I did set the bond at $7,500, which, believe it or not, is lower than the standard amount of bail for that. But I did issue that order requiring the magistrate's order for mercy protection. I have received a request for a modification